All right. All right. Good morning and welcome to the February 2027 public hearing re the solar farm tax abatements. This time it's 10:31 and I call this meeting to order. We could all stand for the pledge. Becky, would you like to kick us off? Becky? What? You like to kick us off? I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Roll call, please. Oh, sure. Yes, please. Oh, here he comes. Sorry, Ed. We're on roll call for attendance.
Mr. Flanagan. Present. Mr. Hughes. Here. Mr. Cantz. Yes. Mr. Mokel. Here. Mr. Webb. Here. Mr. Wyatt. Present. Ms. Piper.
Yes, here. All right, again, questions from the public may be directed to County Council dist@co.delaware.in.us. Again, that's County Council dist@co.delaware.in.us. Marissa, was the agenda posted? All right, I'll entertain a motion to approve the agenda.
So moved. Second.
Motion by Dan, second by Eugene. Roll call, please.
Mr. Flanagan. Yes. Mr. Hughes. Yes. Mr. Cantz. Yes. Mr. Mokel. Yes. Mr. Webb. Yes. Mr. Wyatt. Yes. Ms. Piper.
Yes. All right, at this time, we're at the project updates from our solar farm projects. One of you want to volunteer to go first, Hawthorne, or?
Good morning.
Good morning.
Ben Friedel with the Hawthorne Solar Project. Thank you for your invitation to join you this morning. Happy to be here. Sent a letter that you may have received yesterday. I sent it to Mr. Freeman. I expect he distributed it to you all. Some elements of that letter were provided to the Tax Abatement Committee previously, and just offered a very brief outline of some of the activity that the project has taken on since the tax abatement was approved, the resolution was approved. I can give you a very brief background on our company. I know that, there are many new members of the council since our application was made. And then maybe just offer some insight on normal band project development and the things that we take on as a company as we consider projects like this. So, as I said, Ben Friedel, I am the Chief Commercial Officer of Clean Shift Energy. I was also the Executive Vice President of Development at National Renewable Energy Corporation. Those two companies have common ownership. Hawthorne is a portfolio company of Clean Shift Energy. When we, as a company, we are a developer, owner, operator who constructs solar energy projects in the southeastern United States, mid-Atlantic, and Midwest. We have developed and constructed 650 megawatts in those regions of the country. We're a 55-person company. We're employee-owned. We're based in Charlotte, North Carolina. We've been in business since 2009. As we operate as an independent power producer or developer, owner, operator of solar power projects, we put forth a great deal of effort to thoughtfully site power projects like this. We work in agricultural communities throughout the United States. We analyze land, we analyze electrical infrastructure, and we do deep work in what is referred to as the electrical power markets. We have to compete on the wholesale market to sell electricity. In the instance of Hawthorne Solar, we are governed on the interconnection side by an entity referred to as the PJM Interconnect. It is an independent system operator. It is overseen at the federal level by FERC, the Federal Energy Regulatory Commission. The standards of interconnection, and I'm going to emphasize this again, are vital to the success, stability, and security of our country. Hence why a very large, vast federal agency oversees this exercise. It is heavily scrutinized, heavily regulated, and the process and procedures that we have to go through as a private company, we bear all of the costs associated with that process. And it is it pushes in this day and age, it pushes a decade worth of effort that a private sector company has to take on. You can review through national publications all of the activity that has occurred through the interconnection request process that has elongated the effort that we have to go through. And it is a vital effort because it is key and critical infrastructure to some baseline functions in our society. Solar project development is not much different than natural gas power development or nuclear power development or coal power development. And we all compete on the same market, the same rules. As an independent power producer, we are not a regulated utility. So we bear all risk associated with the project. And that was grounded in the need for competition so that customers can receive the most efficient deployment of technology and the lowest prospective power rates. And as technology evolves, those of us in the private sector, we advance the progress, and that risk is borne by us, and that is how the regulations are structured. We have been developing Hawthorne Solar since 2019. I alluded to the electrical study process. Until we knew we had a viable location, we did not reach out to the county. But once we knew we had a viable project and a viable location, based on all of the fundamental factors and analysis and risk that we took on, we then initiated our outreach to the community. That was done as has been recorded here in 2021. We greatly appreciate the professionalism of all of the county staff and administrators that we've worked with. At that time, there was a solar ordinance in place, and we reached out to economic development to pursue a tax abatement of some form. It is a commonplace in our experience inducement for investment or continued investment in a project like this. And they take many forms and shapes all over the country. And in the state of Indiana, they take the form of a tax abatement agreement, a tax abatement. So I can make a best efforts basis to answer any questions that you may have about our project. The project is located in Delaware Township. It's near the Muncie Dragway for a general directional. It is slated to be a 75 to 83 megawatt alternating current project that is governed by our interconnection agreement with AEP and the PJM independent system operator. And we are continuing to spend money on all of the necessary work that we have to do. We have, I believe, as you all know, the moratorium expired at the end of last year, and there is now an ordinance that is live and active. We have been working with county planning and their consultants, and we're looking forward to scheduling a more formal, detailed meeting with them so that we can, more clearly understand how the ordinance will apply and all of the procedures and practices associated with the ZBA. So that's where we stand today. I'm happy to answer any questions that you have.
Could you give us a little better idea of your timetable? When would you expect to seek a special use permit from the county BZA? And when then, if that were approved, when then would you be looking at commencing construction?
So that process, as the ZBA dictates, requires certain notice to the community at 2 levels. And once again, we're waiting on Kylene and ZBA and their consultants to inform us precisely how all of that is going to work. There are some obligations that we need to determine who is responsible for, whether it is the county or it is us, as well as they have a bunch of meeting timelines that we have to meet with them. So that is currently unknown. We are, working diligently. We'd like to move as quickly as we possibly can move, but we have to do that thoughtfully. And that's where we are.
What has been, sorry, Bill.
I'll go, yeah, just a couple more. Based on what you know, do you think that you will be able to comply with the current design standards under the comprehensive zoning ordinance
Based on what I know with regards to what
to the design of your project?
So we have, there is how the ordinance is applied to our project is feedback that we're currently looking for from the planning office. There are as you also may be aware, there is some embedded flexibility in the ordinance itself. So there, we can continue to work with the land partners that we have associated with the project to refine our project design, and that is all in process.
Roughly how many acres would be involved, or the range of acreage that you're looking at?
With respects to
how many acres would be involved in the size of your project?
Yeah, so as has been reported to the county previously, right, we have roughly 700 acres under lease. How many of those acres will be ultimately under the project or inside the project boundaries is to be determined.
And your tax abatement that was approved was for personal property only, not for the land, is that correct?
Yes, sir, that is absolutely the case. Personal property is what the tax abatement applies to. There is a state standard that the state legislature has determined for solar utility property.
Right. You report your
real property.
investment to the state and they determine the assessment.
Well, both the personal property is reported as well as the real property. Right, so there is a real property impact.
One other question. You have not entered into any agreements with the county commissioners, economic development or road use or decommissioning. That's all yet to be done.
So our project, right, was in process with the economic development agreement, road use agreement, and the decommissioning agreement, and and the moratorium was instituted as we were in process with that, which plausibly would have affected that agreement. So we decided thoughtfully with the county council as well as economic development to put our pencils down on that for the time being.
Okay, thank you.
Is there a plan to sign an economic development agreement?
Is there a plan to?
Prior to a project beginning, the actual project construction beginning?
I mean, there's certain elements of the ordinance, as it's currently crafted, that would require agreements that would be exhibits to the economic development agreement.
So is that a yes?
I foresee that that's our path forward, yes.
Okay. Because in the other instance that we're referring to here, there's a payment to the county associated with that. There's the road use agreement that Bill referenced. There's a decommissioning agreement there's some level of detail, I guess you could say, around those things that I would think are important to the conversation that we're having, just simply around the financial piece, correct? So,
Understood, yeah, it's a conventional structure, I don't mean to overuse that word, but yes, abatement followed by economic development agreement, lots of investment is induced that way, throughout the state of Indiana. Additionally, other parts of the country use very similar mechanisms.
but it's fair to say that the ordinance that you guys are needing to take into account, the ordinance that was passed to determine what your final investment's gonna be, your final, size of the project, et cetera.
So, right, we're doing all of that work now.
Mhm.
Making a determination as to how, if at all, it will affect our design.
So in terms of investment that you've made to date, can you quantify that?
I mean, it's in the magnitude of millions of dollars.
And that goes against what the original, that's part of your original submission for the tax abatement, which was, I get the number here, 88 million.
So, yeah, the 88 million was an estimate on the personal property, right, that we would deploy into the facility. It's an estimate, right, the mechanic, in the abatement is a percentage. And there are a lot of moving parts to, coming up with an estimate like that, multiple years prior to procuring equipment and completing final design. So we are continuing to work through all of those variables, and it was always a moving target.
Without the EDA in place, though, there really is no, nothing prevents you all from walking away at some point, theoretically. You've made this investment, you've tried to make it work, the ordinance is in place, whatever reasons come up, theoretically, you don't have to go through with the project,
Based on what in
based
particular?
on anything, I guess.
Right, I mean, we are still, right, what would be deemed as the early stage developments of a project. I mean, we've committed significant amounts of capital. We've signed, agreements you can review, the agreements that we have with both PJM interconnection as well as AEP, to connect our project. Right, and just as would be the case with any development project, right, the project could stall for any reason.
I think Matt asked that question because we have had other tax abatements come before the council and then they never come to fruition, so that's,
Right, I mean, my only comment there, as I mentioned previously, right, a tax abatement, and I'm just speaking, common language here, it is an inducement for future investment. These projects are, infrastructure projects, they're vital to the, safety and security of our society as a whole, and abatements often function in scenarios like this to both induce that investment as well as, recognize that, projects like these, solar projects in particular, do not stress, county resources, don't increase traffic, don't stress EMS 911, but yet are ultimately, net material contributors to the community, both in job creation as well as, increasing the tax base.
Do you have any other current projects in the state of Indiana?
Yes, sir, we do. We have 2 other projects active in the state of Indiana currently, and our construction team is just won a bid, on a 4th project. We have a project that has received site plan approval in Huntington County, Indiana. And, we have another project in, Whitley County.
I would argue that taking fertile ground away from farming is not just the, only, the only offset that you guys have there. So, but, just in all due respect relative to that, I think you're gonna hear that from probably some folks in the audience at some point, but, relative to the life cycle of the solar farm, to your point, it is a stagnant thing, it's sitting there, in theory, generating electricity and what have you. The life cycle of the farm though, so you mentioned that it's unclear to me why, unlike a building that was created that could be resold, solar panels aren't gonna be resold in 10 years. Fair? As in your equipment that's on that property will have a life cycle of a certain 20 years, whatever the number is, right, for whatever.
Certainly, I mean, you build an infrastructure project like this,
Right.
It gets underwritten to have a life cycle.
And the
that's-
decommissioning of it, in essence, then is around taking it all out and returning the farmland to where it was, the state that it was.
Yeah,
in
that-
most
I mean,
cases, correct.
that is governed by the decommissioning agreement itself.
So I think the disagreement on the giving of the tax abatement is that you are investing a certain amount of equipment into the region. You're not really creating any jobs because of it necessarily, and that equipment eventually goes away and may or may not have environmental impact to that land that it sits on. So that's the reason, just to lay it out, why we're having this discussion. That make sense?
I mean, I follow, your statement. I can't say that I agree, with what you're saying, but I follow what you're saying.
Why do you think that, why are somebody who's paying 5, 7, 10 times the amount, of a acre of farmland needs a tax abatement from the county that they're going into?
Sorry.
Why is that typical? Why is that typically and you said it's typical that tax abatements are given to these solar projects?
Mhm.
Why, because of that equipment investment, because of jobs created, like why is that?
Yeah, I
The
mean,
case.
I can't speak specifically to the why, but what I can say is there are significant ancillary benefits to a community for projects of this nature, and, that is recognized, by, economic development offices, and, they use the tools that are available to them to induce the investment. If you'd like to understand some elements, the legality of it, or elements of tax, I have our counsel here, is well-versed with a long track record, of operating the state of Indiana in economic development, Richard Hall from Barnes and Thornburg, and he'd be happy to share some insight there.
So I have just a couple more questions. Have you paid your property taxes on any of these leased lands to date?
We don't own the land.
So no, right, so you
don't
guys
own
are not actually putting, other than the investment for the technology, you're not paying any taxes.
So we don't own the land.
Yeah.
So, right, so
Right.
the tax burden, and there's no physical equipment
Mhm.
on the
I mean,
property.
I knew
don't-
the answer, I was just making sure. Okay.
Yeah.
All right, and then, both companies stated in their abatement application, and this was a question actually from somebody in the public that came through the live stream, which is around, the environmental impact or answering in the application none to whether there was any environmental impact to the project. There was some information provided to me, and I think maybe others, around some other land leases that indicate that that isn't necessarily the case. There may be a contradiction to that. Is it none? I mean, do you expect zero environmental impact based on these projects?
I mean, the standard of expectation is that we remediate the site, to its original condition. If something does arise, and that would also be governed by the decommissioning agreement, or, the private land agreements that we have.
You're gonna regret volunteering to go first, aren't you?
I'm happy to be here as long as you
All
want
right,
me to be.
and then one last question, which is there any plans to build or develop battery storage, or is all that power going straight to the grid from from the panels themselves?
We explore battery storage on all projects that we develop. In this instance, right, the governing document is the long cycle document for how we deliver power to AEP's system, governed by the PJM interconnect, right? And modifying that agreement is an exceptional effort, especially considering it takes, you know, half a decade to codify an agreement like that.
So currently that agreement states that there's no battery storage.
That's the way the design and the agreement reads today.
Good question. Are there any plans for any environmental impact studies after decommissioning of the property?
I believe that the ordinance addresses that specifically.
Could you remind me?
I don't have the language right in front of me, but I believe that there's a standard. You know, the community took a great deal of care in drafting that ordinance, and there is language both in the ordinance itself as well as in the decommissioning agreement that speaks to the necessity of measurement of environmental impacts.
Okay. Councilmember Hughes had asked a question earlier. I may have just misunderstood what you said, but I don't know if I heard the answer. When your tax abatement was originally approved, however many acres it was, forgive me for not knowing that off the top of my head, there's been some significant changes due to the ordinance, 500-foot setback. That was a big pushing point as far as proponents of solar. They told us that the setback would just destroy any plans for anyone to be able to operate any type of facility such as this. Did I miss that? Did you address that, the 500-foot setback, how that will impact your specific plans for this project?
So we are currently assessing the impacts of the ordinance. And as I believe I attempted to mention to Mr. Hughes, that there's a level of interpretation within the ordinance, and there's also some flexibility in how we work with the project land partners, and that may affect our system design.
That sounds like legal talk. What do you mean, interpretation and flexibility?
Well, sounds like legal talk.
Yeah.
I would encourage you to review the ordinance, and what you'll note is that there may be some conflicting language in there, and additionally, there's flexibility in around securing waivers from both involved and uninvolved property owners that would potentially impact our project design.
So if I'm hearing you correctly, there's potential for waivers or other flexibilities you state that would mitigate that 500-foot setback.
It would just modify it, and it's very clear that it could modify the setbacks. We are working with the planning office to better understand how they would like to interpret those clauses in the ordinance.
In applying for a special use permit, they can request variances from the terms of the ordinance as a part of that application process. And it's up to the Board of Zoning Appeals as to whether those variances would be granted in addition to the granting of the special use permit.
Thank you for clarifying that.
Yeah, actually, that is an excellent point, that it is a conditional use, which does allow some level of discretion. And that is a asset for thoughtful planning. Because, right, there are scenarios in which it may be impractical, inefficient, unsafe, to apply the ordinance, you know, in its precise term.
Okay, last question, I think. I don't believe there's been no ground broken. I could be wrong on that. But you'd mentioned a significant investment up to this point. In previous conversations we had someone, it might have been the other company, I believe most of that investment was through contracts with landowners. If I'm to assume, I'm sure you have a lot of design and things to go into it as well, but I would assume a good majority of it is in contracts with landowners. If, for instance, you said things change and the project was no longer feasible, how would your contracts with those landowners be affected? What is your clause? Like, how long do you have to pay those landowners if you walked away from the project?
It's a private agreement. The comment on my private agreements with private members of this community. But you mentioned that, the majority of our expense has been associated with land agreements, and, I don't think that that's an accurate assessment of how we handle our finances as a company. I alluded to a multi-year electrical study process, which requires a great deal of work, electrically. And those procedures and processes are also publicly available in terms of the cost associated with those studies. And that doesn't account in any way, shape, or form for all of the additional soft costs that go into it, to go into a project like ours. Once again, as a private sector company, we take all of that risk, and we have spent in the magnitude of millions of dollars proceeding through that process. And that is the significant gating item from an electrical standard, for a project of this nature.
I know I said last question, but you said something that made me think, am I wrong to understand that these companies are now considered as utilities? Does that not, have a degree of being a public company, to being considered utilities?
So I can only speak to my project. There are regulations that govern projects that vary from state to state. There is a regulatory body that oversees these projects that would, approve, the certificate for, public need necessity. That is standard operations in most states that we operate in, but in no way, shape, or form, are we a utility or a regulated utility in the state of Indiana.
Thank you for clarifying.
I will add, in the letter we received yesterday, that been forwarded to us, it does explain some of the expenses. You speak that they're up into the millions already that you've invested. It says these ongoing expenses include environmental studies, surveys, title work, engineering, interconnection expenses, as described above, legal support, and power marketing expenses. So there are quite a few things that you've already invested in.
I want to touch on the ERA designation. So on the ERA designation for Meadow Forge, it expires, it's listed in the agreement as expiring in 2038. There's no expiration date on the Hawthorne agreement. There's also missing fields in the application itself, on the tax abatement, application, relative to, let me see if I can find it here. That designated area, the actual type of deduction, question marks that were allowed, the amount of years and such. Some of that is supplemented, in other areas of the application, but, it's not really supplemented in other ways. There's a chart that shows it's a 10-year abatement. It shows a sample tax payable year of 2027 through, in essence, 2036. But there is no, and I don't believe that there has to be an end date for the ER designation, but there is no expiration date as it stands today. Obviously, some of the concerns that the public have is relative to farmland being designated as ERA. I think we've covered that in nauseam between the tax abatement committee and other things that, legally speaking, Indiana, I guess it was, I don't know if it was the Supreme Court or whatever, has ruled that farmland can be designated as an ERA, whether we like it or not. And so, but just pointing out that there were some discrepancies in that Hawthorne agreement, in addition to the lack of an EDA that exists, which in essence provides no meaningful, idea of what Hawthorne's agreed to relative to decommissioning, road use, other factors. It also doesn't stipulate some of the challenges we have with the abatement committee about whether the commissioners signed into an agreement on them recouping tax costs if for some reason this tax abatement was rescinded somewhere downstream. So everything's a little loose still at this point, I guess it's fair to say, other than the tax abatement is in place once the project is completed and operational, correct?
There's a lot in there.
Yeah. Slow down, sorry.
And I'm being recorded, so I'm simply gonna say, happy to work with you all to address, whatever may or may not be missing. And
Okay.
it is commonplace for these agreements, well, the abatement and the economic development agreement to work hand in glove.
Yeah.
And as I alluded to before, the road use agreement and the decommissioning agreement are requirements under the ordinance.
I'd like to add just one last thing and just a reminder, clarification. We've had a lot of meetings on this and I've taken a lot of phone calls and emails. I'm only speaking for myself. I can't speak for the other council members, but most of what I've objected to or what I've heard, people having a conflict with isn't necessarily this particular solar farm. Most of the feedback we've gotten is from the other project. My issue with the commissioner's economic development agreement was with the other project. My issue with the county tax dollars going to West Dell that wasn't quite clear of how much was getting was with the other project. I've not really received any feedback about your project as far as from the community. I could be wrong on that, maybe some, but that's just my personal experience. So I thought that was important if we're gonna, play devil's advocate and be fair and open on both sides. I think it's important to know.
Real quick, did you mention an environmental study of some sort?
Yeah, and environmental studies are normal course.
Okay.
Is
Is that a public document, something that can be released to the public?
It is not. It is a requirement, by the state for approving our site plan. And additionally, underwriting requirements require them. So like if we want to receive some sort of, debt financing or any financing from any partner, they have to clearly understand the environmental risks.
But the public doesn't have access to that.
So whatever we report to the state, I believe the public would have access to.
Would you be willing to provide that to us?
I mean, they take many forms, so if you'd like to send a request to us about what specifically you'd like to see, I'd be happy to follow.
You wanna share any other details around your plans from an environmental standpoint? I've heard from other people relative to other fields that have gone in northern areas of Indiana and other things, like they've done work to try to, reduce the visual impact of a solar field in a open space farm, like where you guys are right by the high traffic area on 67 and such. Like, is there plans for, beautification, whatever, kind of coverage, anything like that?
Yeah, the ordinance, as it's currently drafted, does address that, at many levels. And, as well, there can be, requirements put on the project by the zoning board specifically to address, concerns that may arise.
Okay, thanks.
I've got a couple questions if I could, please. At the end of the life cycle on your solar panels, what do you do with those panels?
At the end of the
For
life
example,
cycle,
the turbines, the blades. I was watching some documentary, it might have been 60 Minutes, where, they're out there burying them in some fields in Texas or something. What is the plan, once the life cycle of these panels expires? How do you get rid of them?
Yeah, so they're, remediating a solar project site, I wish I had one of my, project construction team members here, but, first of all, it's nothing, like a wind project. But, the majority of the material, is steel and copper. It is all recyclable.
Does it not contain mercury?
Well, the panels themselves may, I don't believe they do, candidly, but, but I'd have to reference something more, more recent. But but essentially all the equipment on the site can be recycled and remediated, and so therefore, there's a heavy commercial incentive to remediate, that equipment, because it has quite a significant value unto itself based on the raw materials.
Can you comment, I heard on the street that, you in fact do have, obviously land leases with these farmers. Are you starting to pay upfront for a premium currently? Since they've signed leases, are you paying them what you thought the going rate might be for their ground upon completion of the solar farm.
You know, I'm sorry, I'm really not gonna comment on a private, contract.
So you're gonna sell your, energy, your electricity. I assume that you're getting, is it state and federal dollars as well?
No, sir, every dollar associated with these projects is private investment. There are infrastructure projects throughout the United States have, long utilized the tax code. That includes coal, that includes nuclear, that includes transmission project, that includes pipelines. And the tax code is the tool that our government uses, to point the private sector in a certain direction, but the only way to deploy that, is through the use of private capital. And every dollar that will end up, affiliated with this project is a direct result of private investment.
Kind of an indirect, maybe indirect question. So you start generating electricity, where does it go?
Yeah, it's a great question, and I could spend hours talking to you about this, because this is the part of the business that I'm in that I really enjoy. The distribution system serves local, the system serves regional, and it is interconnected throughout all of North America. And there are governing bodies that oversee all of that. The power moves under its path of least resistance. So wherever it is needed, it will go. Due to the way that we connect to the grid, the power can go in any direction that it is needed, and it will be consumed wherever it can be consumed. So that can be consumed locally. It can, if for some reason there isn't an absolute local need that is urgent for that electron, it will flow somewhere else. So, you know, we enhance the power mix locally in quite a significant way. That stabilizes the system, and it operates much more efficiently that way.
You don't see, as these become more common, do you foresee, the electrical rates dropping?
Do I foresee the electrical rates dropping?
Yes, because of what is already on the grid, now we're adding more supply.
Right, so you have,
So supply and demand.
sure, so you have antiquated equipment that is currently delivering power on the grid that is, one of the other things I enjoy talking about is, how efficiency and deployment of inexpensive, efficient power is better for everyone. And there's a great deal of antiquated equipment that cannot compete with solar power projects. And that new electron from a new project, that will get crowded out as a private market should work. So it would be a downward force on power prices.
Can I, so you're saying you're not receiving any federal incentives or any federal subsidies, correct?
Like, yeah, there's no direct federal subsidy or dollar associated with our project.
If that's the case, why do you need local county subsidies, a tax abatement?
Once again, it is the choice of a community, to utilize the economic development tools that they have at their disposal.
You had mentioned that you said you're not designated as a utility, but my understanding is you're required to depreciate the investment over 3 years. Is that accurate?
So the depreciation of the investment, is governed by the federal tax schedule specifically for investments like this.
Which is 3 years down to 30% of the floor is 30%.
That is a moving target, frankly. There are sunsets to that schedule, so it depends on the year that you place the project in service.
Can I just ask for a little more detail? Matt asked a question of why you would, seek local tax abatement if we're not receiving federal, and I believe you said it's the, prerogative of the community to use their economic development tools, but we only do that if you submit an application requesting it. So I guess I'd go kind of back to his original question.
It is, you wanna,
It's just that, it's for competitive reasons, with all the other projects.
Right.
State, really all of it should receive.
Can you reiterate that for the microphone so we can get it recorded?
go ahead, Rick.
Sorry.
Hi, Rick Hall from Barnes and Thornburg, counsel to, the Hawthorne. The reason for the request for tax abatement is just because it affects the economics overall of the projects and makes it more competitive. Having worked around the state in numerous counties, on different, wind and solar, projects, nearly every project that I'm familiar with, has received some form, of abatement to assist in the economics of it and make it competitive and viable in the long term, for the community.
My question would be, does your company go into, or get involved with your project if you do not receive abatements?
So once again, every state is different, and how each state determines how they would like to deploy tax on infrastructure projects, right, would dictate how we go about that.
Hypothetically, you apply for an abatement, for Delaware County, you don't get an abatement. You decide to work with the farmers anyway, they decide to work with you, and you decide to move forward. Is that fair?
The reason the tax abatement request was made was because it was important to the evaluation of the project as a whole from the company. So we can't stand here and say that the company would have gone forward without the tax abatement, if that's what you're asking, basically.
Well, my second part of that question was, are you currently, in development or do you have solar in existence, where you have not been granted an abatement?
I can try to speak to that, I mean,
And you indicated all states are different, I understand that.
yeah,
but-
and that's why it's such a hard question to answer, right? Taxing infrastructure, is an imperfect science, and the states don't always get it right, and so they offer tools to local governments to encourage infrastructure investment.
Does that money then come from the state?
I'm sorry,
Is that,
I,
if you don't get the abatement, and you indicated that it's, did I understand it being somewhat loosey-goosey, if you don't get the abatement, different states might offer different incentives. Is that not what you've indicated?
that is not what I've indicated.
I'm
I'm saying
sorry.
that every state, handles this differently. So it's hard to specifically answer your question, right? So if you'd like, yeah, go ahead. Yeah, I mean, right, so in Huntington County, right, we have a tax abatement. It's commonplace in Indiana, so it is an imperfect I guess what I was alluding to was that it's an imperfect science as to how to tax infrastructure projects. So either the state makes the determination, right, which is what the state of Indiana did in this example associated with real property, right? They made it very clear about what the real property standard was. But they left it to local government to make a determination as to how they would like to tax the infrastructure or the prospective infrastructure investment.
Are you getting any incentives to use on any other project locally?
An incentive,
Like in Huntington and Whitley counties.
Huntington granted us, yeah, that's all public information. Huntington County granted us a tax abatement.
I think we probably should.
I got one more.
Oh, okay, sorry, Eugene.
You said that you're not receiving direct dollars. Would your investors or partners be receiving dollars as far as subsidies or federal and state monies?
That is entirely up to the Congress, federal government, how that is deployed.
But are they getting them?
Are they getting them? I mean,
That was that your question?
yeah, like, right, it is a moving target, right? The new, right, after the 24 election, the tax rules may change.
previous to now have your partners received?
So, yeah, so it is all handled in the tax code. It is entirely handled in the tax code. That's what I'm speaking to. So just
You're not gonna say yes or
Was that a
no.
yes?
I just-
So no, well, it's all, I mean,
one.
it's all handled in the tax code, just like depreciation's handled in the tax code, right? So that is the tool that the federal government has chosen to use to point the private sector in certain directions. So, right, and it's up to us as to how we make our investments as a developer who puts ourselves at risk. And yeah, anyhow, it is not written in stone how that will play out.
Do we have any additional questions for Hawthorne?
Ben, thank you very much for
Thank you.
Thank
being
you.
here and taking that
And going first.
and going first.
All right, move on over to Meadow Forge and their update.
Yeah, thank you so much for the invitation. My name is Matt Muller, lead developer on our Meadow Forge project, Invenergy. In the last 2 years, since the moratorium was passed, Invenergy has continued to develop projects throughout Indiana. We're in the process, probably next month, of completing our project in Clinton County, and we'll make our first EDA payment to them in April. We just broke ground on construction in Sullivan County, and we'll be making our first EDA payment to them in the next month, and expect to start 2 more construction projects on solar in Indiana this year. We remain committed to building the 163 megawatt Meadow Forge solar project here in Delaware County. We expect to invest over the $155 million minimum investment required by the EDA. Invenergy will pay Delaware County the annual $200,000 EDA payment once we are in service. I know there was some confusion earlier about the provision that would grant us a tax credit for an EDA payment we'd already made. But just to be clear, what that is saying, for example, is if in year one we paid the $200,000 EDA payment at the beginning of the year, and later in the year we lost our abatement, then we would get a $200,000 tax credit for that we'd already contributed. I think our lawyer submitted a letter earlier this month clarifying it, but there's not like a new dollar situation, that if we haven't paid anything, we're getting anything back.
Hold on 1 second. So you're saying we're not on the hook for $5 million. You would only be on the hook for whatever you've paid in.
That provision is what it's stating is about making us whole if we've already paid something on the year. So it's a very common clause. It's in other EDAs with other companies that we've seen. I know the 2 in Pulaski with Nexera and Mammoth are. We see that in our other EDAs. So correct, it is not about new dollars as a penalty. It's for money we've contributed.
I think it's.
So the verbiage, yeah, the verbiage, I understand.
Yeah,
The
sorry,
verbiage
yeah.
though is just confusing because it reads as if it was related to taxes, but you're saying it's the payments you're making to the county that would be
Yeah.
recouped.
It's a capital P payment for that payment we've made of the EDA payment.
Right,
Yeah.
not any property tax or whatever.
Correct. Big difference.
So this language is common, and we've seen it throughout the state. So I think that's, though the question maybe an outside counsel or your counsel can continue to review. We still expect up to 250 construction jobs will be supported. Once the project is completed, we'll expect there to be 2 full-time operations and maintenance jobs. Our engineers are still working on analyzing the impact of the new setback requirements to update our designs. While the new setbacks may negatively impact the overall profitability of the project, we do not expect the setbacks to impact our ability to meet our financial commitments to the county under the EDA. We look forward to a more detailed project-specific discussion at those BZA hearings when we submit our application. Along with those setbacks, the project landowners or leaseholders, who are your constituents, will also incur lost revenues. Most of these leases are set up that they're getting paid out by in-fence, and if we have more setbacks, there's more spare land there. We do not believe that there's any legitimate material changes that would provide the council with a proper legal basis to rescind our tax abatement, and we respectfully ask that the council allow the abatement to remain in effect. Happy to give any more project-specific updates, but like I mentioned, I do know that we'll go into a lot more detail on the project specifics when we submit our application.
Is there a time frame for that, but to Bill's previous question?
I think to his point, there's some good discussion that we need to have with how some of these things are gonna be enforced, but the expectation would be this year.
You had mentioned the $200,000 economic development payment. How many payments would that be? I may have missed that part.
Yeah, it's all listed out in the EDA, but it's 10 $200,000 payments totaling $2 million
Over, and how often are they paid?
once a year.
So once a year, 200,000 once a year. And is that money paid to the commissioners, or is that money paid to the county general?
I think that's a question that Baker Tilly in their presentation can go over, how that money can be allocated.
It's paid, and you can get it,
So it goes to the commissioners?
yes.
That $200,000 or $2 million total, it's illustrated in the EDA that's not a fixed number.
Yeah,
If the assessed value of the land goes above $8,000 an acre, there's a reduction in that amount. And the illustrative table shows like a total payment of $1.6 million as opposed to $2 million.
Yeah, I think that's a great question that Baker Tilly could maybe shed more light on. I know we reimbursed the county before for them coming to give a presentation on this, and to have those numbers that they put together. So, we recommend and we're open to working with the county if they'd like Baker Tilly to come in and present again, or anyone that you choose to review this.
The state determines the land base rate on these types of projects. The local assessor does not determine that.
I believe that's the 3 regions that have been set up by the state for that assessed value. Again, really, these are Baker Tilly tax questions. I think they're more the experts in this field.
And that, but I'll just make the point that currently for 2023, the land base rate in our region was $14,201 an acre, which would reduce that annual payment from, instead of being 200,000, it would be closer to 100,000.
I don't have it in front of me, but my understanding is we're making those $200,000 payments every year.
Well, okay. 1E on page 3 of the EDA explains that that's not a fixed number, that is variable based on the land rate. That leads to a second question. I talked to Hawthorne. They requested and were granted tax abatement on personal property only. You were granted tax abatement on land, on real estate and personal property. Is that correct?
Vicky, do you have? Yeah,
According to the abatement application, it's for both.
yeah. So I'm happy to have us review this with our legal counsel, this specific legal question. I'm more of the developer working on developing the project, so happy to get back a specific answer on that.
Well, I was just trying to understand what the difference between the two projects was and why yours would be ground on land, particularly since it's leased ground. It's, you don't own the ground.
Yeah, sorry, I don't have that answer right now, but happy to follow up.
You have an EDA in place that was signed more than almost 2.5 years ago. Would you as a developer be open to opening up that EDA for further discussion, given the passage of time and everything else that's happened in the meantime?
I think that's something that we can take back and consider.
One thing that it shows up in other economic development agreements are so-called good neighbor provisions. And that does not appear in the current EDA. Is that something you would look at?
I am not familiar with any of our EDA agreements in the state, so I can't speak to what those look like.
Your timetable, you said you would be filing for the special use permit hopefully this year. Based on your knowledge of design, do you anticipate requesting any variances from the current standards in the ordinance?
I can't say at this time.
Is there any, Hawthorne made a point, which I appreciated, they are a private developer. They are not a public utility. You consider yourself in any way, shape, or form a public utility?
We do in the sense that we are regulated as a public utility, but to be clear, we are a privately held company.
Right.
Yeah.
Is there, do you foresee any circumstance where you would ask the Indiana Utility Regulatory Commission to take over jurisdiction of this project and, in essence, supersede local land use regulation and have them regulate the design of the project?
Yeah, as that being a legal question again, I can have our attorneys look at that and follow up.
Isn't Christina or you the attorney?
My question is, this is a special hearing for us to consider rescinding the abatement. I'm a little caught off guard that you don't have these answers that we're asking you. Or you don't have somebody who can give us the answers, like, we're good, we could vote here however long it takes, and half the questions we've asked, you don't have the answer to.
My understanding was this was a hearing for us to come to provide an update on the project. I'm happy to provide the answers that I can and follow up after. I mean, I think we've been always happy to provide answers that we can. I think with this being a public hearing, I don't want to say anything incorrect, so happy to follow up with a written follow-up after.
If I remember, I can't remember, you were the original developer, lead developer on the project, were you?
Tom Scoder, 2.5 years ago, was the original developer, yeah.
Okay, that's what, I just wanted to clarify that, because I thought you looked different, so I just wanted to make sure it wasn't the same guy who was here before who was leading the project. A little taller.
Do you have any additional questions?
Are you willing to release any environmental studies that have been done?
I think to his same point, I think we submit them to the state, to the INDR, and I don't see now for any reason that we wouldn't be able to release those. I know we're doing a lot of on-site wetland delineations, many environmental studies, so as of now, I don't see why we couldn't release those. They're state documents.
Yeah, one last thing from me. Since we've clarified that clause that we originally interpreted would put the county on the hook for approximately $5 million in future tax credits, that's not the case, only versus how much money has been paid into the project so far, as your economic development payments back to the county, which I believe you stated 200,000 is your target. Councilmember Hughes said that number could change. Has anything been paid to the county up to this point?
I know we've reimbursed the county for that Baker Tilly study that I mentioned, but other than that, I'm not aware of any payments to the county.
Do you know when it's scheduled to be made?
That first EDA payment as defined would be in the first year after operations. So that $200,000 payment would be once the project's in service.
So once it opens for business and starts generating electricity and it's a completed project, I believe.
So, for example, in Clinton County, that's our Hardy Hills project, we're completing construction, and because of that, we're gonna make our first payment to the county.
Thank you for clarifying.
Yeah.
I think there was a question, I guess more of a question amongst council earlier, and I want to make sure we clarify this out, that any revenue that comes in from these projects, since we're at our max cap, it doesn't actually equal new revenue necessarily, but can reduce the tax rate for the entire county. Is that correct, Bill?
Well, it reduced all the relevant tax rates, but yes, for the county general, it would cover the entire county. For West Dallas schools, it would be Harris Washington Townships, their tax rate.
Would be reduced.
I think they said it was like a $2 savings per person, if I remember right, somewhere around there.
Can I ask a few of the same questions relative to, again, it's a 10-year abatement. You're at a minimum, Meadow Forge as a public utility is for sure, depreciation is hitting that 30% cap in the first 3 years. But relative to just what happens and you guys walk away from a decommissioning standpoint, again, I'll just go back to the statement I made earlier, which, is again, I think in one of the letters we received, you guys said that you weren't receiving federal subsidies or incentives of any sort, relative to this. So, you're coming to the locals to basically compete for this, which, I know it's been a challenge, I'm sure. But, again, unlike a building or a piece of equipment that's been invested, we can't resell that equipment, we can't resell that building, we can't resell these solar panels. Nothing really prevents you from walking away, and if that's the case, there is decommissioning language in your EDA at a minimum to try to Is there any prior examples of that you guys having done in other counties or other states and other environmental impact information? Anything else you can share with that?
Are you talking about an early decommissioning?
Yeah,
Anytime that, we
yeah.
haven't had to do any early decommissioning. I think if you think about these projects, right, the investment cost is up front, and then they earn money over the life selling the electricity. So I think the decommissioning language in this EDA, is very common throughout the state with the other agreements we have with decommissioning bonds, and things like that, and the salvage value. I would say that there is, to that point also, a recycling market when most of this is just glass and steel, so there still is value.
But you've not had to do any.
We have not had to early decommission.
Question about the scope, how many acres roughly would be involved in your project?
Yeah, so it's still gonna be determined, like I said, the engineers are redoing the design with these 500-foot setbacks and some of those other considerations they considered, but for a project this size, I think we stated before, about 1,000 to 1,100 acres would be in the fence. Obviously, it's gonna be spread out farther now, with the 500-foot setback being, like, maybe individual parcels can't be as fully utilized. That's the impact.
Sorry, one last question on the
Is-
decommission. Oh, sorry.
And follow up with just a minute, is your project scalable? If the Board of Zoning Appeals said that's too large, it needs to be closer to 700 acres, the Hawthorne project, is that within the scope of your contemplation?
Yeah, I'd have to talk with our engineers about that one to see, if you're saying if we were told to scale down by the BZA or the zoning board?
Yes.
It might impact our ability to meet the 163 megawatts that are in our EDA, our Economic Development Agreement. But I would have to speak with the engineers and see, so.
I'm sorry, go ahead.
Sorry, just one, I meant to
Mhm.
follow up on the decommissioning. Do you know, like, if there was a decommissioning, and this just comes back to when can that land be recaptured from a tax-based standpoint? How long does that take? How long would that take? If it takes you, how many years does it take from this time you break ground to this project to actually getting it up and going? How long is that roughly?
I think conservatively 2 years would be a concern, but.
And then on the flip side, decommissioning probably is at least that too?
I would assume shorter. I mean, it's just removing versus kind of the electrical is, that's a big part of the complication, so I would assume shorter than that also.
Just so we're comparing apples to apples, you said 1,000 to 1,100 acres under panel, is that correct?
I believe in that, and yeah, that's a rough estimate, yeah.
Ben, if you could, how many acres under panel? Right, you said 700 acres leased, but it'd be less than that under panel, correct?
And that's why we oversign acreage because we do these environmental studies, we do these, engineering studies, and we work within the counties so that we can come down to that number.
We'll stipulate at one point I did work for an electric vehicle company, so I don't say these things, so they're not haphazard in my questioning, so don't take them as such. But I appreciate you providing the input.
I would add, you were asking that question about like, why would we come to the county? And I think why are some of our county partners interested in this? I mean, our county partners are looking at ways to get new dollars through these economic development payments, but they're capped at these property taxes, so that's something that's being considered. And then to his point, it's about being competitive to get these projects built.
Yeah.
So that's why
I
we
think
come to
the flip
counties.
side to that is the unknown factor. Just like you've never decommissioned one of these things, we don't actually know what that long-term impact is going to be. They're all new. You guys are throwing darts, 1,000 darts at a time, trying to get as much solar in as humanly possible. It's no different than putting out a COVID vaccine in a matter of minutes. We don't know the actual impact to those things. So that's why the questions are being asked, primarily by the residents. I mean, we're the voice of that, but that's that, so.
I have one last question. You'd mentioned something about, economic development teams wanting to partner with companies such as yours. Can you state, for the record, did your company reach out to us, or did our economic development team reach out to you for this project?
It's happened before, like you mentioned. I'm not Tom, who was working on this. I would say, I can't say to this specific one. It's commonplace when we approach a county, we might for example, in a Pulaski County project, we're signing up land, we're talking to the county, letting them know, and usually the economic director reaches out to us, or we reach out to them. It's kind of both ways. So I know that's not a very clear answer, but I can't say in this specific incident.
There was one other public question that just came through relative to wildlife permits. Do you have to file for wildlife permits to any protected species like bald eagles in this area?
So that is all captured in our environmental studies, kind of identifying if there's any endangered species that we need to be aware of.
Well, in relation to that, any of your properties under lease, we're all operating on the assumption that this is open farm field. You don't have anyone who has wooded lots that they plan to clear to make way for your solar panels, do you?
Again, the state regulates all of that from our perspective, so if we were intending on clearing any woodlots, we'd have to get to the state for that.
But to your knowledge, you don't have any of that right now?
On none of the projects I've worked on have I seen us clear cutting for the purpose of putting solar panels.
Thank you.
I just want to make sure that I'm clear on this with the EDA. You're only talking about the $200,000 payments. We're not talking about the abatement itself. Are those two separate things that there was a recension of?
So in the economic development agreement, we agree to pay, kind of in injunction with this tax abatement, we agree to pay, $2 million over 10 years.
Right.
So to what you're saying, since nothing's been paid yet, we wouldn't be on the hook for anything.
Well, what has your investment been thus far? Do you have a ballpark range?
Very similar. It's in the millions of dollars. Mostly those interconnection studies that he was mentioning. But I do think that clause that has been discussed here is specifically talking about our $200,000 payment to the county,
Which hasn't been made.
which will not be paid until we are in until we are in operation.
I want to ask about the battery storage relative to your project. Is there going to be one?
We do not anticipate we don't have a battery, we don't have any storage position. That's what this interconnection, no. Short answer, no.
Ben or Bill, do you have that statement that was in section 11, Andy, that we were concerned about?
I know we also sent a letter, was that early in February, kind of addressing this specific.
I have a letter. I
clause?
just want to make sure that we're all on the same page.
No, I don't disagree with the interpretation that Council Wheeler sent. That's the February 6th letter for clarification. And her summary under section 11, Meadow Forge receives a credit for any of the amounts paid to the county under the EDA on its future tax payments. So they're not recouping the abatement, they're recouping the direct payments under the paragraph 1 of the EDA. I agree with her.
Could you clarify the number of local jobs your project would have?
Yeah, so the number of local jobs will depend at the time of construction, how many are available. We always want to use as many local workers as we can. We work very closely with local unions to incorporate them, but until we actually get to construction and have a plan, I can't say for sure. But it's our priority
But to be fair, those construction jobs are temporary jobs. What about full-time jobs?
of those two,
Two.
like those two, again, if we would love to hire 2 local families to work as those O&M jobs, it'll just come down to who's available in the county.
Okay, but it's 2 jobs.
That's an estimate. Usually it's about 2 per full-time maintenance, O&M maintenance jobs, yeah.
Okay, thank you.
All right, have we exhausted our questions, council?
I'm finished.
All right, thank you.
Yeah, thank you.
At this time, I will open the floor up for, public comment as it pertains to the tax abatement itself, as that's the only portion, that the county council is responsible for. So if you'd like to come up to the podium, we'll give you 3 minutes, and I know I'm sure we have a lot of people who have comments, so try to, keep your comments unique and not repetitive of those in front of you. Please state your name, and, we'll go from there.
Good morning, Council. Stephen Brand, 8770 South County Road, 200 West, Muncie. I live in Monroe Township out by Cowan. First question is, do you guys intend to vote on this today? If not, I'm going to hold my comments until the meeting where you do vote. Or are you going to wait to gather more information and get the answers to the questions that you asked that were unanswered today?
I personally would like more information, but
If the motion's made and seconded, there'll be a vote.
Okay, then I'm gonna go ahead and share my, my comments. So I've been involved in, small and large businesses here in Delaware County for the last 35 years, and I've requested and been granted tax abatements. I've launched hundreds of pieces of business, and not every time do I come and ask for a tax abatement. I had to come before this, county council multiple times to request and report out on the status of my abatements in terms of real estate investment, capital investment, infrastructure, IT, jobs, payroll, all those things. And I'm glad to say that we always overperformed and exceeded the expectations on our abatements. And I believe President Piper was president for all of those. I was always challenged when I requested an abatement that, is this required to get the project across the goal line? Have you already signed a contract with your customer? And I learned very early on that you don't come and ask for an abatement for a project that you're already going to do or that's already been secured with your customer. And as evidenced by the testimony that you heard this morning, they had already worked, secured land contracts, and then communicated with the county and came and asked for the abatement. So I'm not necessarily against or for solar, right? That's not the purpose. You ask for abatement. And I think I've been granted 5 or 6 abatements in my time running small and large businesses. And the purpose is to get the project across the goal line, not necessarily to sweeten the icing already on the cake. So if you look at the timeline of events, I believe a business and a responsible business, which I believe both of these are, they've already done their risk assessment. They know, hey, without this ordinance, I'm still going to do this project or I'm not going to do the project. Without this abatement, I'm still going to do the project or I'm not going to do the project. And they secured land contracts. They've spent millions of dollars, and maybe the solar ordinance doesn't go in their favor, and maybe the abatement doesn't go in their favor. So I just ask that you consider my comments and my personal experience with abatements in this county. While it may be different in other counties or in other states, that's not the way it's been done here, at least in my experience. Thank you for listening to me today.
thank
I
you.
appreciate it.
Thank you.
Is there anyone else who'd like to speak on the abatement? All right, we'll close, oh, okay.
My name's Tim Nickum. I live in Harrison Township. I would just say that if the motion is made today to rescind these tax abatement, I would ask that a second also be given and a vote taken so that the public knows exactly where you all stand on this. We would appreciate that. Thank you.
Thank you. All right, anyone else? All right, at this time I'll close public comment. Do you have any comments from the council? Yep,
I just
yeah,
respond very quickly. Deeply appreciate the sentiment and comments. I wanted to clarify one point because I believe that you hit the nail on the head. We approached the county once we had enough preliminary information, such as, comparable to a different business, where you do all of your scoping analysis and your preliminary work, and you're very thoughtful about what it would and would not take for a project to be viable. And it was at the point of recognizing that we had the prospective project that we reached out to the county to talk to them about any economic development inducements that may be available. So it isn't that we're looking in any way, shape, or form for the icing on the cake. And we're in a highly competitive marketplace. as we've spoken at, on nauseam here today. And we're competing with projects all over the state, all over the country, frankly. So
But doesn't that lend itself that we then, Delaware County was competing with you, you were competing here, you were competing in other counties. You've come to the realization that you can get however many land leases in place, that's enough to put X amount of megawatts of power in that place, that makes it a viable project. Then you're coming for the tax abatement.
Well, the requirements for us to even apply for the right to deliver our power to the electrical grid requires the agreement.
Right.
Then we have to wait for the results of the electrical study,
Right.
which is a multi-year process.
Right.
Then before exercising the county, right, we want the results of that electrical process. We have a viable ability to deliver electricity, and there's no meaningful fatal flaw. And now we approach the county collaboratively to pursue the opportunity, which has knock-on benefits to the community, based on the assessment of the county. And hence why the pursuit of the agreement.
So it's your opinion that the abatement pushed it to the finish line?
Right, so there was a.
And you would have not come because of it?
The thoughtful combination of an ordinance, right, which was codified, and thoughtful economic development induced us to continue to put ourselves at risk, to try our best to, develop and construct a viable project that competes in the open market. Just wanted to make that statement. Additionally, there was a note about jobs. Yes, I'm not in conflict with what the other company suggested, but there are significant ancillary jobs that occur throughout the course of the life of a facility like this, beyond the construction jobs. The ancillary jobs have a net economic benefit to the community. And there's ongoing training and skill development for the electrical trades that projects like these benefit.
Thank you. Part of the counter argument to that has been placed or sent to me multiple times is around, and this came into why the solar ordinance got reduced from 30,000 acres, whatever the number was, and reducing that level of tillable ground in Delaware County, there's a reduction in potential jobs on the flip side of that. So that was,
Understood.
part of the argument
Yeah.
from the get-go.
Understood.
Thank you.
So,
Are you looking for a comment?
yeah, I mean, I know that we have had some executive sessions to talk about some legal ramifications of different things, and I think we have some clarification now on the reimbursement side of it, but I think that there's still possible litigation that could come down the road, so I wanna make sure we all keep that in mind as we're making decisions, but
So I'll just start, I guess. I don't even know where to start, to be honest with you. I appreciate, Ben, you guys sticking around. I appreciate the honesty and the input that you guys have provided. I have concerns, obviously, that there is no EDA in place. There is still an opportunity, and it's the same with any abatement. You simply could, decide this isn't gonna work, and there's no EDA ever, and there's really not a project, potentially down the road. I mean, you've invested a ton of money. I doubt that's the case, but, I do appreciate that you guys have been willing to do that. You've been, much more forgiving and willing to participate in this process and not as confrontational as your other cohort that was here earlier. So I do appreciate that. I'm torn, personally speaking, on a multiple levels. I've got, a lot of people that I trust and talk to that feel adamant that this abatement should not have come into play. I know why they came into play in the first place. I realized why that investment looked enticing at the time. We as a council now, obviously, will be doing, I think, a much better job at reviewing tax abatements going forward to make sure that those things are tried to work out as much as we can ahead of time. I do think that there's still a lot of unknown factors that, you know, are here. The legality of it is the legality of it. Do I think Hawthorne's gonna sue us? Maybe, maybe not. Do I think Meadow Forge will? Probably, they will. That's been their position from the get-go. They're very adamant about it. They don't seem to mess around and don't wanna screw around, and they're much more, you know, less about the private investment and more about the public utility component. All those factors play into their potential impact if we were to decide to rescind. With that said, I don't disagree with, Mr. Tim there that we should probably put it to a vote and see how it goes. Even though Meadow Forge didn't answer the questions that Bill started asking, I didn't anticipate, I was surprised that, Christina has been vocal from the get-go, and today she didn't say a word, so it's kind of weird, but, so there is that, but, I do think that we should probably try to reach a conclusion on this once and for all. I am a economic development, I am a business person. I wholeheartedly believe in economic development. I do tax abatements do have a means to an end. In this case, there's some philosophical differences between solar and green energy versus, and the actual reality of those those energy sources, and what some people believe and what other people would believe. You can believe whatever you want. The reality is we don't know, in most cases, the actual impact to our county, how much tax money we're actually going to save or not save. A lot of that is unknown in most cases, but in this case, it's obviously a lot more controversial given that that land may or may not be able to be reclaimed properly, and if so, when, if these projects in 25 years disappear, which most likely that will occur, in my opinion. These solar energy projects are short-term, federally subsidized reasons for those companies to exist and to try to make a dollar, just like anybody else. I can't blame them one iota. I would probably do the same thing if I'm in their shoes. But the reality is we're giving away money based on that, and to Mr. Brand's point, you know, I think in hindsight, people should have thought twice about getting somebody to the finish line that was already being invested. So, all that being said, I do think that that we should make a motion to, well, we're gonna have to make them individually if we do that, I assume.
Right.
It's
Two individual
Well, before you
texts, but-
get there, do we have any other comments from council?
Yes, please. Actually, the impact of all of this on our primary reason for sitting up here, the county budget, is practically nothing. So it's not a fiscal question. In my mind, this really is a question of land use. When this goes before the Board of Zoning Appeals, and I commend the commissioners, they had the foresight to make these special uses as opposed to permitted uses, the way the ordinance was originally written. Board of Zoning Appeals has broad authority for this type of request to grant or not grant a special use, and in doing so, they can impose reasonable conditions as a part of the approval. I think my problem from a land use point of view, and I did a lot of land use law when I was practicing, is the scope of the Meadow Forge project. I think it's excessive. And I would like to see that scaled to a more reasonable level. This question about litigation, and we should be very clear about that. The concern is, does the council have the authority to rescind a tax abatement once it has been approved? As our council, and I worked on this with him, pointed out, in general, if a council has the authority to approve something, they have the authority to repeal it at a later date. That based on the Indiana Home Rule statute. Council for Meadow Forge in particular, but I think council for both projects were in agreement that no, the tax abatements is a different kind of an animal once granted, to the extent that these developers have relied on that in any respect, they're entitled to the benefit of that abatement. there's no case law. We don't know what the answer is. Legislature has not seen fit to tell us what the answer is in their legislation. So it's, to use a legal term, it's a crapshoot. And, I think the council has to think long and hard before we say, well, let's go to court and find out what the answer is. Because lawsuits are time-consuming, expensive, and ultimately both parties don't like the result. There's never a clear winner and clear loser in most litigation. So that is a very real concern. Having said all that, I think it's worthwhile that we find out how the council feels about this, so that A, we can get on about our business, and B, these other individuals, all concerned individuals on both sides of the question, can move on to their respective interests. So that's where
Council members have?
I feel better about the metaphor, because it's just the property instead of the land.
there are lots of things I don't understand about Meadow Forge. I don't understand the distinction of them being a public utility. That concerns me. I don't understand why they were granted abatement on both land and personal property. And I think we ought to note for the record that when they concluded their presentation, they left the public hearing.
So, Bill, can you help me with that? The real versus the land in terms of those calculations that we saw? And to your point, it's really not that dramatically impactful, but ultimately, they don't own the land either. So how is it that they're going to, what is the benefit for them on that abatement?
I think they receive the benefit of the abatement because they are legally obligated to pay the taxes. I assume that's the reason. Again, they don't share with us their private agreements, their lease agreements, but I assume that's the reason. And I assume that was figured into Baker Tilly's determination that ultimately the tax benefit to the company in Meadow Forge's case was going to be something a little over $5 million.
I don't know, Rick, is that something you can answer relative to, is that accurate that you will be responsible for paying the taxes on the land once the project, or once you guys are complete and operational?
What's the,
You might go on the mic, sorry.
once the, property is, operational, then under the state statute, it goes to the assessed value for the real estate. So somebody's gonna pay that increased amount of taxes once it's operated. Now, who pays that between the landowner and the developer is a part of the negotiations of the lease. At the end of the day, the county's gonna get the money, and if, and that would obviously, in the relationship between the landowner and the solar company, impact what kind of, rentals are paid, depending on who pays the taxes.
Let me say one other thing, and that is, I've been critical of the Meadow Forge EDA. If Hawthorne goes forward with their project, I don't want to see an EDA that looks like that. And we need to have an opportunity to have input on that negotiation.
Oh, I'm glad you brought that up, Councilmember Hughes, because the EDA was one of the things that kind of left a bad taste in my mouth. I don't like the idea of us making a vote and then an EDA being crafted after the fact that we're somehow legally bound to. I've never understood that. Honestly, I don't believe it's accurate. I mean, there's a lot more attorneys in the room, and I'm not one of them, but, I just don't believe that we'd be held responsible for an EDA after we've already voted on it. But I agree with you on that, if something is put in place, that we should have some sort of input with that. I also appreciate the fact that you noted that we have two companies here, one stuck around for the decision and the other one left. So thank you, Representatives of Hawthorne, for sticking around. And you know, this has been an ongoing thing. We've got so much information, and then we found out that, I mean, that certain information we thought was true wasn't true. For example, we thought, we interpreted that economic development agreement to believe that we were somehow be on the hook for, $5 million. And I think that kind of immediately shut down any real efforts. I know a lot of folks are probably that give them pause to really look at, rescinding this. And so I'm relieved today that we've clarified that that's not the case. The county would not be on the hook for $5 million. To clarify what he said was any money they pay out, because they've not paid out any yet, we would be on the hook for future tax credit for however much they paid out. So if they paid out $200,000, we'd owe them $200,000 in tax credit. But because they've not paid out anything, we wouldn't owe them anything. So much has changed in this project, with the moratorium. I believe this was 2021 when we first did this. And, moratorium was put in place, and there's been quite a few changes to the solar ordinance. 500-foot setback is the one that kind of gets brought up the most. Councilmember Hughes had mentioned something earlier about a good neighbor clause that a lot of companies have in their agreements, and that's lacking in this particular one. So that would be something we'd like to see in there. I mentioned something earlier today, and I said that for a reason, that most of the people who's gotten up to that podium and have spoken have been in opposition to the Invenergy solar project. Again, I'm only speaking for myself. No one's called me about Hawthorne. There's not an economic development agreement for Hawthorne. Kind of got lumped into this because we did them all on the same day. So when I made this motion back in November to consider rescinding tax abatements, it kind of pulled into that, but really it was just, by association, to be honest with you, from my perspective. And we went through this proper steps. We've had some hearings, and here we are now. We're all the way in February. It's went on forever. And, Mr. Nickum, I appreciate your comments about, expecting a vote, and I'm glad that Councilmember Cantz, agree with that, because I agree with that as well. I believe that it's time to, either make a decision or, and live with it, not kick the can down the road. Before that whole $5 million thing kind of scared people, there was some consideration, and it was even brought up at one point. Someone had said, maybe we could ask the companies to withdraw their tax abatements and refile, in light of all the new information, right? It's a lot of new information, almost a whole new council, with the exception of 2 people. And it'd probably be a lot more appropriate. We have a lot more citizens notified of it now, who can share their objection or not share their objection. And I thought that was a great idea, but then that kind of got spooked away with that whole misinterpretation of the economic development agreement clause. So, with it being said that there's no case law, this has never been done before, as far as I understand. No community has ever rescinded an economic development agreement, or I'm sorry, never rescinded a tax abatement that had been previously granted, and there's no case law on it, and it's all up in the air, and they may sue us, they may not sue us. I've shared some frustrations in the past about us. I feel like sometimes we may fold our hand out of a threat of litigation, and I don't really like doing things that way. I feel like if you feel like you have the winning hand and you're in the right, then, you stand your ground. Yes, it's scary that there's no precedent set, and it's scary that they probably got lawyers on retainer from here to wherever. But, it is what it is. And if we think that we're in the right, and we think that we have the right to rescind an abatement that we previously granted, then I think we should stand on that. And I came in here prepared today. Obviously, I wanted to hear what everyone had to say, but I've been listening to the citizens of the community for a long time, and I know what's expected and what they're asking for. Matt had mentioned a minute ago about doing these separate, and I think that's an appropriate thing to do. So based off of what I had recently said about my differences between the 2 companies, I'm gonna make a motion to rescind the abatement for, the Invenergy tax abatement. And I'm hoping that someone seconds it, because I feel like, the community is owed a vote. That's my motion.
I'll second for purpose of discussion.
All right, we have a motion by Ryan and a second by Bill, to rescind the Meadow Forge tax abatement.
Now, we're done with council comments.
I,
Well, you can discuss now.
yeah, we
can
just
do-
discussed,
we're
yeah,
open
it's part of
discussion now.
discussion at this point.
Sort of cut the rest of us off there by doing that, Ryan. I appreciate the motion. I'd like to clarify just a couple things. Matt, you said something about the leases are 10 times the amount of what a farmer could get for rent. I wanna disagree with that somewhat. I've seen a couple of the leases. I'm gonna say it's closer to maybe 4 or 5 times the amount that rent is going for
Yeah,
right
you'd
now.
rate 5 to 7, so I may have misspoke.
I mean, it adds up when you're talking to farmers' pockets. And I'd also like to clarify, the land's not taken because the land was offered up to lease by the landowners, whether that was farmers or absentee landowners. So none of the ground has been taken as of yet. I don't know if anything will have to be eminent domain for utility rights or not, but nothing has been taken. I mean, I agree with you, Ryan. Previous council, hate to throw them under a bus, but made a poor decision in my mind. And with all the information that we've heard now, I probably would not have been in favor of tax abatement when it was presented to the council at that time. But you all made that decision and we're dealing with it now. I am just gonna tell you how I'm gonna vote now. I'm not in favor of rescinding it for one big reason. I don't want this county to rescind abatements to companies, and then every other company that wants to come to Delaware County see that we've done this, and then decide we're gonna go look somewhere else. Because we've already heard in previous meetings, our poverty rate significantly high. We don't need to be turning away any jobs. We need to encourage growth and high-paying jobs to come to our county.
I'd like to jump in for a minute if I could. My background is that I was born and raised on a farm. And for that reason, I would just like to say, I think farm ground should remain farm ground. I am also want to make sure that people understand that I am not opposed to solar. I think solar is needed. I think it's a great resource for energy. However, I think that there is a place for solar. And again, I don't know that farm ground, in my opinion, and I know that the state has said different, but for me, I just don't think that's a good use for solar. We have all kinds of ground that is contaminated. We have, I'm sure in Arizona and in Texas, vast majority of ground that is sand. Sunshine is probably 364 days out of the year. And to me, that would be a great place for solar. You know, down the road, it bothers me a little bit, I guess, that for some reason I keep thinking solar will bite, just, you know, the old saying, how do you eat an elephant? One bite at a time. And with that in mind, again, so many things going through my mind right now, but one thing is farm ground to me is a viable commodity that needs to be used to raise crops. And again, there are places for solar. I think solar is great. I just think it needs to be put in an area where land usage for crops is not affected. I would prefer not to see this go from 700 acres, whatever Metal Forge has, then, you know, it goes to 10,000 acres. Then first thing you know, 15 years down the road, here we got 30 or 40,000 acres of solar. And I'm going to tell you, my great-great-grandchildren can't eat electricity. Maybe people have a different way of doing crops. I don't know. That's one thing that bothers me a little bit. But then let me also say, if I could, that I respect the people that were here before me on this council. And the people that were here were good people. They voted unanimously to approve this tax abatement. And I think it is a detriment at this particular point in time, with everything else that I have said. I think it is a detriment to the county to rescind the abatement. Again, to say I'm in favor of it, I'm not in favor of it, but the flip side of that, as Councilman White has already spoken, I think sends a terrible message to those people who, at this particular point in time, could be looking for some tax abatements, and if granted, would always have in the back of their mind, what is the next council going to do? Are they going to move forward with this abatement, or are they going to possibly rescind it? Both companies have spent, according to them, millions of dollars, with the understanding this tax abatement would be granted. And for those reasons, for myself, Mr. Whitehead has already expressed his opinion, I would move forward with the abatement.
You both brought up some really important points about not being opposed to solar, and I think that's really important to mention. Yeah, I don't think anyone's opposed to solar. I'm not opposed to solar. I think to have as many options available, you know, to contribute to the consumption is a wonderful thing to do. Planning and competition is a good thing, and who knows, the cream rises to the top. Maybe it will one day prove to be the best route to go. I don't know. People tend to move away from fossil fuels, but my position is more about, you know, with whether it was misinterpreted, the information was there all along, and it was missed, or however you want to say it. My understanding is different from what it was that day when the council voted in favor of it. I tend to believe that if you get information that changes your mind, and you have the authority to be able to change your mind, then you should be entitled to do that. Had I known half of the things we know now, I would have voted differently that day. I'll be the first to sit up and tell you, I was on that council and voted to approve it unanimously, and I've been very open about it. I think that was, for me, that was a mistake on my part. I can't speak for anyone else. They may stand behind their vote, but for me, I would have definitely voted differently. Councilmember Whitehead mentioned about that there's no land being taken, and he's correct. And, you know, this is a difficult conversation because I'm in favor of property rights, right? If you live in the county, you should be able to do what you want to do with your property. Now, we've had people sit up here and say, well, that's not necessarily true. We have a CAFO, and they don't let us do what we want with our CAFO. We have restrictions on that. We live out in the middle of nowhere, so there are limits, there are restrictions. But I want to make it clear and understood, tax abatement isn't going to be the be-all, end-all of a property or of a project. I think these multi-million-dollar, these tax abatements are really drops in the bucket compared to their profit margins of what they make on them. And so I don't think it would affect anyone's right as a property owner to still utilize their property if they want to lease it to a solar company. No one would infringe on that. It would just say that we're not going to give up free tax dollars in the 89th ranked poverty ranked county in the state out of 92 counties. We're not just going to give away free tax dollars for a company or a project that's already going to be very profitable. That's all that was saying. Now, I get it. It takes courage to be first. It takes courage to say, to step off the ledge into the unknown, and nobody's ever rescinded it, and we don't want to be the county of no, and I totally get all that. But when you get information that makes you think differently, I feel like you have to act on it, and I can respect anyone's position who says, you know, I don't want to go against something that's been previously done. I don't want to send a message. But you got to stand on your principle. If the information that we know would cause you, if you were sitting, you said it yourself, if you were sitting here that day, you would have voted against it. Well, if that's your opinion on it, I caution people to be bound by a loyalty of not wanting to be the first in the state to ever do it, and to not want to send a message to any potential future developers. You got to go with what your instincts are telling you, whether you would support it or not. obviously you can vote however you want, but for me, I'm gonna vote on how I feel I would have voted knowing the information, and now I know the information, and I would not vote to support it, so, that's how I would do it, and I appreciate everybody adding their comments.
I had Mr. Brand's thoughts kind of in the back of my mind that, these people already kind of had leases signed, so what do they need our money for? And then, apologize, can't remember your name. Ben, so, thank you. Anyway, Ben stood up and said, we have to have all this done before we can decide if it's valuable or not. It's like, so you gotta have the property lease, so you know how many acres you got, and figure out a way to connect it to the grid before you can come and say, yep, we can do this, or, well, we have to write off all this money we just did. So that was, that kind of changed an opinion of mine. I'm in agreement with Mr. Mogul here that, farm ground should stay farm ground. But I agree with him also that I don't want to be the county to know. And I don't like that. That just puts me in a bad spot.
I think if you, oh, go ahead. Go ahead, I'll go last.
To Dan's point, I don't disagree that what Ben stated is accurate. However, it's not unusual. Everyone's gonna do that due diligence ahead of time before they decide they're gonna come or not. Tax abatements are also used for existing businesses to invest and stay and get some breaks to invest internally. Again, I think that's a big focus area that we need to bear in mind. And so I believe Ben is speaking his truth, and he's true to that, but I also don't necessarily believe that would have changed anything, necessarily with that. And there's also, I don't know whose point was about local solar versus industrial solar. Industrial solar is the controversial version, and this isn't unique to Delaware County. This controversy is happening in other counties in Indiana and probably across the country, as well, with industrial solar, impacts versus local solar. I think in hindsight, the county commissioner should have taken this on as a local project instead of what has come to be. You know, the city and other, folks are looking at doing that in other areas, and we did not, probably because we're short-sighted. So that's part of the reason why I think that we're here today. So, but I also agree, we don't necessarily, from a material change standpoint, is probably not, in our best interest, but I agree with Ryan to some degree that, in the case of Meadow Forge particularly, what's happening with them is different than what's happening with Hawthorne at this point. Hawthorne not having an EDA could be looked at as negative, which I initially thought. In some ways it may be a benefit because it actually would give potentially us some opportunity to work with them and figure out a better solution for everybody going forward. So I would be opposed to rescinding anything for them. However, that is not the case necessarily for
So, what I wanted to share too, I mean, Ryan and I were the two sitting up on this bench when this tax abatement came before us. The information we were provided, everything sounded great. We had zero opposition. I mean, Ryan can remember.
Yes, ma'am.
No one came, so we made decisions based on the information we had at that time and zero opposition. Would things be different now? Possibly. I know we had some good conversation with the commissioners in our executive session pertaining to updates to the tax abatement form. I believe, Ryan, Matt, you may have had some additional suggestions that they were open to adding to the form. I think they're gonna have a lot more eyes on our tax abatement process. I'm sure Mr. Hughes will definitely be looking into those a lot deeper than prior tax abatement committees, which is a great thing. Like, that's a positive, that's a win for all of us. One thing we haven't covered in all the time that we've been here, knowing now about that section 11 with the EDA, that calms some nerves for people, but I do want to explain what was told to us is because we had signed those tax abatements. That was just mainly an agreement. The commissioners were just saying, yeah, they've signed off on this, so it's going to happen, because there is no history of anyone ever rescinding an abatement. So that's where that came from. And to Jim's points, I mean, there are a lot of brownfields that would be a good use for solar. But before us today are the abatements that we put in place based on the information we had. at the time with no opposition, so. Any council have any further comments before we go on?
Let's read that motion again.
The motion was motion by Ryan and second by Bill to rescind the Meadow Forge tax abatement.
And could I also add to that, that my desire is for it to be rescinded and them to resubmit it with all of the new information to be reconsidered. I believe that's what we'd spoken about previously, not necessarily, it would be a deal breaker, just so much has changed. I would like to see a different request with all the new information. Now, that, obviously, we can't put our hand on that. They gotta make that decision if they wanna reapply or not. But that was my desire with rescinding the motion, to ask them to reapply with new information.
So the motion has been amended. Do we have a second on the amended? So now are we voting on the amendment?
Please read your,
So we'll vote on the amendment.
I think that could be taken as a friendly amendment.
Okay.
He just clarified his original motion. He didn't
Okay,
really amend
that's fair then.
it.
All right, so motion stands still, original motion, Ryan and Bill, to rescind Meadow Forge.
For the record, that was resolution 2021-037.
All right, roll call, please.
Mr. Flanagan.
So they have the option to resubmit or not turn them down outright,
But it doesn't stop.
but it doesn't stop the litigation. No, let's keep it as it is.
That's a yes.
That's a no to rescind.
No to rescind.
Mr. Hughes.
No,
Mr. Cantz.
Yes.
Mr. Mokel.
no,
Mr. Webb.
Yes.
Mr. Wyatt.
no.
Ms. Piper.
No. So Ryan, are you good with, Hawthorne's abatement?
I never had no personal objection to Hawthorne. I was just, so yeah, I'm good with just what we've done.
Yeah, I want to stipulate what I said earlier too, that, there's been no, as much public outcry. There's been a lot less controversy in some respects, but at the same time, the same concerns exist, to that. And the need or non-need for tax abatement supplements to do the project are, are still there, in my opinion.
I think it'll be a much more scrutinized moving forward.
Absolutely.
What we've learned from this, I believe. At
This
least for me.
council, I think this council, and you'll find this when we talk about our next tax abatement next month, this council needs to adopt guidelines and standards as to when we're going to consider tax abatements. We have nothing right now. Everything is an ad hoc decision, and that's a poor way to make these kinds of decisions.
Well, Bill, as the chair of the Rules Committee, would you like to take that on?
Well, the tax abatement committee will take that on
Take that on? Okay,
with input from all the council members.
great. All right, do we have any comments from council before we wrap up? I think we probably said everything we need to say. All right, with that, I'll entertain a motion to adjourn.
So moved.
Second.
Motion by Dan, second by Matt, all in favor? Aye. All right, with that, we will close up our meeting. Thank you. Council, don't leave until